16. It's March 18th, 2019, and Beyonce and Jay-Z's firstborn child is now 7. Blue Ivy Carter is 7, and she still doesn't have the trademark they tried to get for her when she was born. They first filed a trademark application back in January 2012. They filed an intent to use application. They filed an application in January 2012. They filed an intent to use application. There were no problems with the application except for there was an office action issue saying there was likelihood of confusion with another mark. They amended the trademark application, overcame that, and the application was published for objections. No objections occurred. And since they filed an intent to use application, they were given allowance to use the mark in commerce. So what this means is that they have 6 months to actually prove that they were using the mark in commerce from the time that notice of allowance was used. So let's just kind of break this down from the beginning. So they filed an intent to use application. So what this means is they filed an application that says, and actually we're going to go back even further. Some people, if you're not in my group and you don't follow me, you don't even know what an intent to use application is or what a trademark is. So let's even start back. So from the beginning, trademarks. Trademarks protect brand identifiers, right? Brand identifiers are those things that indicate the source of a good or a service. If it doesn't indicate the source of a good or a service, meaning who made this thing, it's not a trademark. We recognize trademarks as, trade names and logos and slogans, but trademarks actually protect other things like colors, smells, sounds, shapes. Anything that really identifies your brand can be used as a trademark. There are 3 things or 3 requirements that are needed for your mark to qualify as a trademark. The first thing we've already talked about, it has to identify the source of a good or a service, right? That's thing number 1. Number 2 is that it must be used, your product or service has to be used in commerce or interstate commerce, which is in multiple states. And the third thing is that it has to be unique. The mark has to be unique. So it has to identify the source of a good or service, it has to be used in interstate commerce, and it has to be unique. If it's not those 3 things, it's not a trademark. So there are 2 types of application. You have the in-use application that says, hey, I'm currently using this mark in commerce right now, all graving. And then there's a second application, ones that the Carters filed, which is an intent to use application. In the intent to use application, what you're saying is, hey, you know what? I'm not using this mark in commerce right now, but I have a bona fide intent to use that application in commerce. All right, so I'm not using it, but I plan on using it in commerce soon. So that's what they filed. It's cool. It's all gravy. So in the case of the intent to use application, there's a fourth requirement. And that requirement is that bona fide intent to use application. You can't just file an application to take the name off the market or prevent somebody else from using the mark. We can't do that. So they filed the application, and then I think it was January 2013, January 2013, they were given permission to use this mark in commerce, which is awesome. So 6 months later, they weren't using the mark in commerce, they filed for an extension of time. So with an intent to use application, you can file an extension of time every 6 months up to 3 years. And so if you're not familiar with the legal T, what we do here is take stories from pop culture and use it to break down, legal stuff. So in this case, I'm using this story of Blue Ivy Carter to break down this whole trademark process. And the reason I'm bringing it up, even though it started 7 years ago, is because they're still in litigation. Matter of fact, the opposing party just filed something on the 11th. What was that? 7 days ago. They just filed something 7 days ago. So it's back up. It's still going on. So I want you to take some lessons from this so you can avoid that situation, right? So here we go. So 6 months later, still not using the mark, filed an extension. They filed an extension all the way up to 2016. They filed an extension every 6 months up to 3 years, and then guess what they did? They lost their application. They lost their trademark because they never were able to submit proof they were actually using the trademark in commerce. But, so that was in February 2016, but right before it expired, or right before the trademark application was abandoned, they filed another application. Another application for the same exact mark they filed in January of 2016. This time, someone by the name of Veronica Morales filed opposition to their trademark registration. So what happens in the process is you file your application, it sits in the database for 3 months, for 33.5 months until it's assigned to an examining attorney. That attorney looks at it and says, hey, I think your mark is confusing with someone else's, or hey, I don't think you should get this trademark, or whatever the reason is. They look at it to determine whether or not you should be able to get this application. In the case of the second application, they didn't see any reason not to give them the registration, so they approved it for publication. Now, during this publication phase, what happens is you give the public 30 days to object to the registration of your mark. Anybody that has a real and legitimate standing can file an objection. And if they believe that that registration of your trademark is going to harm their mark in some type of way, they can file an objection. And that's what she did in this case. She actually filed objection under three things. Just really talk about one. And so the main reason she filed, her first reason was that they didn't have a bona fide intent to actually use this trademark, right? The second reason, there was a likelihood of confusion. Of course, she claimed likelihood of confusion. Her mark, by the way, is Blue Ivy, and she's a wedding or an event planner. She said she's been using the mark since 2009, but she didn't file a registration for it until 2012. So in this process of the first mark, the first Blue Ivy card mark, going through the process and being approved for publication, and then that whole waiting period, she came in and filed a trademark for Blue Ivy. Now, she's used it since 2009. Blue Ivy was born sometime in 2012. I don't know the month, but she filed her application like in July of 2012. She was approved for registration, and she actually filed her Section 8 back in last year, I think. So that's where we are now. She filed this objection saying, hey, do not approve this mark because I know you didn't see anything wrong with it, but if you file this trademark application, if you approve this application, it's going to harm my mark in some type of way. And the reason we don't want you to do this is because, hey, USPTO office, they're not even going to use this mark anyway, right? And so let's talk about a bona fide intent. So bona fide intent is not like someday I'm going to use this mark, It's not a placeholder for when you finally get your life together. One day I'm going to start this business, and when I do, I'm going to use this trademark. You can't do that. So with a bona fide intent, you have several factors that we look at to determine whether or not you have a real bona fide intent to use this application. And that first thing that they're going to look at your statements. Like, they're going to look at previous statements that maybe might indicate that this was just something to reserve the name. And in this case here, Jay-Z he did an interview with Vanity Fair, and he basically said, when he was asked about it, they said, hey, we heard that you filed an application, Beyonce filed an application for Blue Ivy Carver. What's that about? And he was like, matter of fact, he has his exact words. He said, we only did so nobody else could. People want to make products based off our child's name. When anybody's trying to benefit off your baby's name, it wasn't for us to do anything with. And as you've seen, we haven't done anything. First of all, it's a child, and it bothers me when there are no boundaries. So he's admitted that they just filed this trademark application just to prevent other people from doing it, which you can't do. And this is something that you need to know as well. When you file a trademark for a name, and that name identifies a person, especially a famous person, or any name really, they make you file consent. You have to have that person's permission before you can file a trademark for their name. So, for instance, if somebody wanted to file a trademark for, Steve Harvey, they would have to have Steve Harvey's permission before they can even file that application, no matter what class it was in, no matter what, right? So that's thing number one that you have to realize. So what he was trying to do was prevent people from doing that, but I guess they were saying that she was just born, so her status wouldn't be recognized as a person who they needed permission or consent to get that name. So they wanted to take these precautions. Right? So number one, they're going to look at your past statements. If you ever made a statement and said, I'm just using this name just to make sure that nobody else is using it, then that's going to be used against you when they're looking to see if you have a real intent. Number two, they're going to say, hey, okay, you filed this intent to use application and you said you're going to use it in association with these goods or services. Where are they at? Where are they at? Do these products actually exist? Does this service actually exist? Give us proof. And that's what Morales asked for in her discovery. So here's another side note. When you turn the application in, it goes to an examining attorney, right? But once that objection is filed, it leaves the examining attorney's desk and it goes to the board and it enters litigation. During litigation, they have this process where the parties can gather information from one another, and that's called discovery. So during the discovery request, Morales, she said, hey, where are these products at? You said you were, and they have a whole list of products. They said you said you want to have products doing this, that, and the other. Where are they at? Where are these products? Give us proof. Let us know that you're actually working on this. Give us proof and show us these products that you said you were going to use his name with. So that's what she asked for. She asked for products. And if they can't do that, that's not going to look good for them. Especially since they've been working on it since 2012, right? The third thing that the board will look at is this thing even feasible? Can this product is this product something that can be created? Sometimes it's not just, our trademarks aren't just associated with the common run-of-the-mill product. It's not just someone creating a phone or a microphone or, sunglasses, right? Maybe it's something that has to be created. And they're going to say, hey, does this technology even exist to create this product? And if it doesn't, then you're in trouble, because if the technology doesn't exist and there's no product, and there's no product, then there's no trademark to associate with the product, right? So if it's not feasible, again, that's going to be used against you. History. Your history with the particular product. Let's say you've been in business. Some companies have been in business for years, and they have, and they're known for one type of thing, right? They're known for one type of thing. They're going to look at that. The board's going to look at that and say, hey, you always do X, but now you said you want to do Y, right? We need some proof that you're actually going to do Y. But because in your history, you've never done Y before. And in this case, if they look at the history, one of the things that Morales pointed out in her objection is that, hey, this is not the first time they filed this application. This is actually their second application. In the first application, they didn't do anything with it. You approved them to use the mark, and they could not come up with proof that they were actually using the mark in commerce, and they had 3 years to do so. So look at that. Look at their history, and you'll see that this is their pattern, right? Especially if you combine it with the Vanity Fair article that says, hey, we have no intention whatsoever of using this mark. We just want to do it because no one else can do it. The fifth thing, and so the funny thing about this one, we hear about, identify your market all the time, but that's one of the things that USPTO is going to look at when they're looking to see if you have a bona fide intent to use application. They're going to say, hey, have you identified your customers? Who's going to buy this product? What have you done to make sure that this product has someone to buy it? They're going to look at that, and if you can't produce that list, then you're going to be in trouble. Have any firm decisions been made? Before you launch a business, you have so many decisions to be made. And if those firm decisions have not been made, it's going to count against you. One of the things, just an example, is your product going to be sold online or offline, right? That's a firm decision that has to be made. If you haven't made that decision yet, then you're in trouble. And let's take it one step further. Let's say your business is going to be online, right? Okay, awesome. What platform are you using for your business? What platform are you using? All right, so if you don't have those firm decisions, then that's going to be held against you. So let's say your business is offline. If your business is offline, okay, cool. Where are you going to sell your products at? You don't know? That looks very suspect. Which brings us to our final point is, what have you done since you filed this application? You filed this application with USPTO under oath, saying that you had this bona fide intent to use this trademark application or this trademark in commerce in association with products or services. What have you done since you filed this application? Have you done any type of work? This is not a type of process where you just kind of file it because one day I'm going to have a business, and when I do, I want to make sure I can use this mark. No, what happens is, because when you get ready to launch a business, it's a process. It takes a lot to launch a business, and you should be working on that as you do your trademark application. The reason you're filing this intent to use application is to make sure that as you're working on your business, the name does not get taken, because with trademarks, remember, they look for same or similar. So what you hate to happen is, as you're building this product or service and you're getting your marketing together and you're getting your branding together and getting ready to launch, and it comes launch day, and then you come see me for a trademark clearance search, I'm like, oh, I'm so sorry. Someone took your name already. There's already something same or similar out there. devastating, right? Devastating. All the time, all the money that you spent doing this, and now you can't even use it. So that intent to use application actually gives you priority over anybody who might actually use the name or mark after you. That's why you file an intent to use application, so that you can make sure that your name and your logo and your trademark is protected as you're actually building and launching your business. It's not I just want to do this. This is a catchy name. I'm gonna do something with it someday type of thing, right? So there were a lot of lessons from this story. And if you're just coming on, what we were talking about is the Blue Ivy Carter trademark, how it's 7 years later and we're still, they still don't have a trademark. And this is actually their second application, right? They had one application that they filed an intent to use for, and they never did anything with it. They went through the entire process. They got a notice of allowance, and for 3 years, they did nothing with that mark. And so they filed another application, except for this time when they filed an application, a wedding planner filed an objection to it, and she said, hey, don't give them this trademark. They've already told us that they're not going to do anything with it. Don't do it. So, and if you do, it's going to be confusing with my mark, when her mark is Blue Ivy. And so that's that whole thing. But I know we had a lot of lessons out of here. We talked about what it takes to have a trademark. We talked about objections. We talked about intent to use applications. We talked about what bona fide intent is. But if I had to summarize our three takeaways would be this. Our first one would be, you can't file a trademark application just to prevent somebody else from using it. You can't do that. That's takeaway number one. You can't file an application just to prevent other people from using it if you don't plan on using the mark. The second thing is, don't file a trademark, an intent to use trademark application, unless you really intend to use the trademark in commerce. If you don't plan on using the mark in commerce, don't do it. Do you know that you file an application under oath? Do you know that there are penalties associated with fraud against the federal government? People think that, it's just a U.S. trademark application. U.S. United States government. All right? So we don't want to lie to the feds intentionally. When you file that application, you are submitting that application under oath that you are actually doing what you said you're going to do in this application. So you don't want to do that. The final takeaway I would say is that this intent that you have when you file your intent to use application, it's more than just a someday type of thing. It's not like I would really like to have a business one day. Oh man, that's a really great name. I should trademark that, so when I get ready to start my business one day in the future, when I have no idea where it is, it'll be available. No. The intent to use is more than a someday type of thing. You have to be able to provide proof that you're actually working on bringing that product or service to the market. All right? Take care.